Good morning, everyone. I hope you're all well. Nice to see us all virtually assembled for this very interesting panel. So thanks for the invitation to chair, because I'm excited about even some of the merging themes just in the initial information in the program. So this is going to be interesting. I particularly like that there really is a focus on all the sorts of variety of environmental issues that we face, because at least often in my field, it tends to be climate, climate, climate. So I really appreciate the diversity of this panel in terms of what we're studying. So I also am going to stop rambling, because that's not the point of this wonderful panel. So we'll take about 15 minutes each to present, and then hopefully we will get through everyone. And if we can keep on time, I would appreciate it, because then it does allow for questions and for comments from everyone. So first up, we have Rosemary Mwanza, who will present on Toxic Spaces, Community Voices, and the Promise of Human Rights, the Owino Uhuru environmental pollution case in Kenya. So Rosemary, if you could start us off, please.
Okay, good morning, everybody. I think I'll start by sharing my screen, because I'm going to use a PowerPoint to do my presentation. I hope. Just give me a minute. Oh, sorry about that.
That's fine.
So, good morning, everybody. My presentation today is based on a case study I have conducted on the Owino Uhuru pollution incident in Kenya. And my aim in conducting this study has been to try and posit an approach for framing corporate pollution that brings to the fore the certain aspects that may escape the narrow framing of the problem, as is usually is the case in the context of public interest litigation. And the findings of this case, I must say, are already outlined in a recent publication of mine. But due to time limitations, my presentation will just be a brief outline of some of the key findings. You will notice that I've changed the title a little bit, so that it can reflect what I'm going to talk about in the next few minutes. So to set up the background of my analysis, I will first provide a chronology of the important events, and then I will follow this with an overview of the salient roles of each of the main factors. And then lastly, I will reflect on the regulatory implications of their contribution in this incident. So as you can see in this diagram, there's a lot that was happening in this case, or a lot that happened in this case and continues to happen, but I've just picked the ones that speak more to what I'm going to say. So this pollution incident concerns the exposure to pollution by a lead smelting plant that was located close to the Uhuru Owino community. And the Uhuru Owino community is an informal settlement located in the coast of Kenya. And the genesis of this incident goes all the way back to 1930, when the settlement began. And this settlement, those settlements in the coast that usually pull folks who traveled from the interior to go and work in the newly formed farms and companies that were cropping up before the British set up the colony and shortly afterwards. And in most cases, residents of informal settlements in Kenya do not hold formal land rights. So they are usually persons with limited economic power and opportunities. So another important event is that in 2010, a new constitution was adopted. And this constitution contained what has been described as a near exhaustive Bill of Rights to replace the old constitution that had been in place from 1963. Then regarding the case in particular, or the incident in particular, takes place between 2007 and 2014, when a company known as Metal Refineries EPZ Limited started operating a lead smelting plant. And this plant was located a mere 50 meters from the community's borders on what is called an export processing zone location. An export processing zone location is simply a geographical area designated according to the law, and it is usually designated for the purpose of attracting foreign and local investors by providing tax and other incentives. And this type of programs took root in Kenya in the early 80s and up to date. They are quite an important part of export-oriented trade. Then in 2016, because of the pollution, members of the community instituted a human rights class action in the High Court seeking compensation and other remedies. And the court found in favor of the communities for the communities. And what the most important development is that the court relied on reinterpretation of the polluter pays principle, according to which responsibility for remediation, cleanup, and compensation was apportioned between the operators of the smelting plant and public officials whose conduct was implicated in the occurrence and the worsening of the pollution event. And shortly after the judgment was delivered, the state quickly appealed. And the crux of the appeal is that the High Court's interpretation of the polluter pays principle is erroneous. And at the time of this presentation, the appeal is still pending. So in light of the victory of the first round sorry, let me go back a little bit. In light of the victory of the first round of litigation, it is very tempting to to stretch the triumph of environmental rights, and this is to an extent true because this was the first time a case such as this has been litigated up to this point. And it is also a case in which the High Court issued one of the biggest compensation orders in the country. It is also noteworthy that environmental human rights in Kenya have come a long way. For one, the constitutional petition lodged by the community relied on environmental human rights that were not part of the 2010 constitution and on procedures that stood on shaky grounds within the legal framework that was in place before 2010. However, while researching the background of the case, I made an observation that motivated my focus on the issue of how we frame environmental problems and whether how we frame them could enable those actors involved to harness the transformative potential of environmental human rights better. And the observation was that human rights litigation does not always address issues that necessitate structural reforms. And this is because in the context of litigation, the scope of issues is informed by, and in most cases, limited to those that serve the interests of the clients. So in this case, it is in terms of obtaining compensation to protect clients' immediate well-being, particularly if they are from disadvantaged background, as are the members of the community in question, and also to stop ongoing pollution as a matter of immediate concern. So based on this observation, I hypothesized that whether human rights can be used effectively to tackle environmental problems depends to a large extent on how environmental problems are framed. So in the following two slides, I would just like to highlight quickly the contribution of the main players before proceeding to highlight how I frame this problem or how I use these facts to frame this problem. So the main contributors are here. and I'll just speak briefly about what their salient contributions have been. So the first one is the smelting company, the MRL. So its contribution is marked by persistent violation of environmental standards, having been accused of polluting throughout its active years from 2007 up until its closure in 2014. And this is on top of operating without an environmental impact assessment license for over 14 months, even though that's a precondition that is mandated by law and it is central to environmental governance. And the second crucial aspect of its contribution is in the form of allegations that the company participated in attempts to suppress the efforts of environmental defenders who were attempting to shed a light on what was happening. And it is argued in the sources that I have contacted that there was use of threats of violence and intimidation. And in fact, one of the environmental defenders had to go to hiding. There are also reports that suggest that this was done with the assistance of the police. Then the third aspect is that arguably when the owners of the company realized that the environmental defenders were not going to let up, they attempted to escape, in my opinion, legal responsibility through what I believe is to be opportunistic dissolution and transference of the environmental impact license to other corporate entities to continue lead smelting activities in the same location. And it turns out that the new corporate entities to which the EAI license was transferred had been formed by the same actors who were the owners of MRL. And this was done twice. So apart from MRL's contribution, their public officials also played a crucial role. And in my research, I found that I could class these public institutions into two groups. There are public institutions whose mandate relates indirectly to environmental protection, and those whose mandate relates directly to environmental protection. And the first one is the Ministry of Trade and Industry, who has power to designate a geographical area as an EPZ location. In this case, the minister used that authority to designate an EPZ a mere 50 meters from the community's borders. And the designation was done notwithstanding the fact that the informal settlement had existed for long before EPZ programs took root in Kenya. Then the second public authority is the Export Processing Zone Authority, which is a body that is charged with the responsibility of promoting and facilitating export-oriented investment. It has the authority to issue EPZ licenses to qualifying farms, and one of the core conditions to qualify as a farm to operate in an EPZ location is that the farm has to provide proof of a valid EIA license. And in contravention to this requirement, the authority issued the EPZ license. So even though these two don't have a direct responsibility for environmental protection compared with the three whose contribution I will speak of briefly, it is clear that their participation has played a role in producing the pollution incident as it turned out to be. Then the third one, most important public body, is the National Environmental Management Authority, NEMA, which is the premier environmental administrative body in the country. And it has a mandate to enforce environmental laws and policies. NEMA's contribution was in allowing the operations of the smelting factory to start and continue for more than a year without an environmental or social impact assessment being conducted as mandated by law. And when NEMA finally issued the EIA license, it did so without the prior participation of the members of the community. So throughout this incident, environmental defenders continued to raise complaints. And what NEMA did was it conducted intermittent investigations and one audit, and it used intermittent administrative closures, arguably to force compliance only to turn around and allow the farm to reopen and continue operating without having produced any tangible compliance outcomes. The other body involved is the Ministry of Health and Sanitation and the Ministry of Medical, the Office of the Medical Officer, which is charged with protecting health at the municipal level. And these two bodies were also engaged in the same type of conduct as NEMA. There were investigations done, closures were recommended because these two bodies don't have the power to order closures. No, actually the municipal council has the power to order short closures. And the same thing happened. The closures were short and the company was reopened shortly after. No tangible environmental or health outcomes were produced from these closures, and still the operations went on. Then there is also what I found to be the use of the investigative machinery, which is what I want to talk about now. In addition to all of this that the public officials were doing, there were two main investigations conducted. The first investigation was conducted by the Public Complaints Committee, which is a complaints committee established under the main environmental statute. And the committee similarly recommended closure to enable compliance, but this does not appear to have been done. And the second one was conducted in 2015 by the Parliament Standing Committee on Health. And the recommendations from these investigations were far broader. It recommended remedial action, including cleanup, replanting, and testing, but still nothing came of it. And a case was instituted through a constitutional petition in 2015. So in my last slide, I just want to speak briefly of what it is I have made of pollution incident that takes place against a backdrop of a flurry of activity by public officials and a near exhaustive bill of environmental human rights. And I believe the starting point would be to frame pollution in terms that capture more than the linear adversarial relationship between a perpetrator and a victim by highlighting some of the most important contextual factors that have played a role in producing the visible adverse effects that usually push litigants to go to court. So I have used the metaphor toxic spaces, and I borrowed this both from geography and sociology. And I found this phrase to be compelling, or this metaphor to be compelling, because it allowed me to conjure corporate pollution as a phenomenon that is constituted both of the social material aspects in that particular location and the interactions between the various actors, and the relationships between these actors is shaped by legal, historical, structural, and economic and other factors. So I'm just going to mention 5 briefly. And what this does is to show that the humanitarian and ecological consequences do not tell the whole story. So the first thing I took note of is persistent violations of environmental standards by public and private actors can be construed as a manifestation of a deep-rooted governance challenge associated with an indifferent, violent, and marginalizing state. And this is not just a one-time problem. And the second observation I made is that the use, or in my opinion, abuse of the corporate form to avoid legal responsibility implicates the design, content, and underpinnings of corporate law. Then the third one is that the use of the machinery of environmental governance by public officials bears the marks of bureaucratic violence. I understand bureaucratic violence to be a structural governance challenge that occurs through the persistent and deceptive deployment of various aspects of the state's massive bureaucratic machinery to keep the promise of change and justice in view, while failing to take any decisive action to bring about change or to protect people. Then finally, the designation of the EPZ location and the licensing of a highly polluting industry near a residential community suggests that the genesis of environmental problems, and in this case, I think it bears the mark of environmental injustice, is sometimes embedded in seemingly benign laws and policies, and ultimately how those laws are enforced. So what does this imply for the use of environmental rights as a regulatory response? The few observations that I have presented here show that environmental human rights should not only support the immediate demands of judicial remedies, but also be able to underwrite far-reaching reforms that target the deep-seated structural problems that play a critical role in producing adverse effects of pollution. And I note that while a single analysis or the analysis of a single pollution incident may not serve as a template that can be generalized to all cases, the analysis suggests that there is need to adopt a particular framing of environmental problems that could better serve as a springboard for identifying responsive legal and policy interventions. So that will be all from me. Thank you for listening.
Thanks very much, Rosemary. Excellent presentation. We'll move quickly on to Loveleen Bullar, who will present on water pollution, pharmaceutical effluents, and human rights, corporate accountability through the lens of antimicrobial resistance. So, Loveleen, the floor is yours. I don't know if you have slides to share as well.
Thanks very much, Jennifer. I don't have slides to share, so you'll just have to see my face through this entire presentation. I just want to start by thanking the organizers for including me in this program. And I really enjoyed yesterday's sessions and Rosemary's session, which I think really resonated with a lot of what I've been thinking about the title of my presentation, which again is a really, really long title. I need to find a way to compress it. So just to get started, again, the title of my presentation is Water Pollution, Pharmaceutical Effluents, and Human Rights, Corporate Accountability Through the Lens of Antimicrobial Resistance. I just want to break the title up a little bit first. Starting with corporate accountability, the definition of the term, according to Grant and Keohane, is the actors being held accountable, have obligations to act. So there's an obligation to act in ways that are consistent with accepted standards of behavior, and that the actors will be sanctioned for failures to do so. So there is this idea of answerability and enforceability. When we come to corporate accountability specifically, it's often referred to as publicly traded companies' performance in non-financial areas such as social and environmental sectors. So who is to be held to account is the kind of first question. For what should they be held to account, and to whom should they be held to account? And then, of course, the really important question of how do we hold them accountable? In my paper, I focus on the accountability of a particular set of corporations, that pharmaceutical manufacturing units, for human rights violations or abuses, which result from a pollution of a natural resource. And the natural resource that I'm interested in is water bodies. So in a departure from some of the presentations yesterday where there was a focus on extractive industries, I'm looking at water as a recipient of the pollution in a similar way to Rosemary's presentation on pollution. And the overall context in which this presentation is situated is that of a global public health issue, which is antimicrobial resistance, which I think is also interesting because it really, really emphasizes this very close link between health and environment and some of the challenges that come with trying to figure out solutions to these issues. So I want to first kind of set out the problem. Now, the globalization of the supply chain has, of course, led to outsourcing of production of both finished pharmaceutical products and active pharmaceutical ingredients that go into those finished products from the global north to the global south. One of the reasons for this shift, of course, is that the fact that cost of production is low, and this is because perhaps there are weak or non-existent environmental and or labor laws, or the implementation is not quite effective. This, of course, has led to an exponential growth in the pharmaceutical manufacturing units in China and India in particular. Production is economically profitable, and the supply of pharmaceuticals has increased significantly. Now, this is fantastic, but the corollary to this pharmaceutical production has been antimicrobial resistance. What is antimicrobial resistance? This refers to the ability of a microorganism, such as a bacteria, fungi, virus, and parasite, to resist an antimicrobial drug that was once able to treat an infection by that microorganism. This is the WHO definition. This means now that AMR is predicted to cause 10 million deaths a year and a cumulative loss of USD 100 trillion of economic output by 2050 if it is left unaddressed. So it is a significant public health challenge in the coming years, and this has been recognized at the international level and the domestic level. Now, there are multiple pathways for the emergence of antimicrobial resistance. These include human beings. So, for example, excessive use of antibiotics as medicines. They also include animals, for example, use of growth-promoting antibiotics in poultry, and also the environment. And this is the third dimension of the environment that I wish to focus on. And one route for the origin of AMR in the environment is the discharge of antibiotic effluent or antibiotic residue from pharmaceutical manufacturing units into water bodies in the surrounding areas. There are a number of studies that have found that insufficient wastewater management in these pharmaceutical industries leads to the discharge of antibiotic residues into the surrounding environment and the emergence of AMR in the environment. This AMR could then get transferred to human beings. As a result of the emergence of AMR in the environment, there is a problem of water pollution, which affects the quality of water that is used for different purposes. This then can have very serious impacts on both individuals and communities who either live near these polluted water sources and therefore rely on these water sources for different uses, and also on the environment, which becomes a reservoir of resistant genes that go on to spread antimicrobial resistance. The consequences are violations of a number of human rights, firstly of these individuals and communities, and these include the rights to life, health, food, environment, and livelihood. These violations also raise the issue of justice and equity, as the affected right holders are often socially, economically, and politically vulnerable individuals and communities. And of course, these issues concern not just the present generation, but also the future generations of right holders. What is interesting about AMR is also the fact that the visibility of the crisis is often postponed. It is not as soon as antibiotic residue is discharged into the environment that the impact is experienced. And that introduces another layer of complexity and also highlights the need for a preventative or precautionary approach. So we're not just talking about providing remedies for right holders after abuses or violations have taken place, but we are considering a more proactive prevention of those situations themselves. This brings me to the response to this global public health and environmental challenge. Here, I wish to rely firstly on the UN Guiding Principles on Business and Human Rights, which among other things state that states should consider a smart mix of measures, national and international, mandatory and voluntary, to foster business respect for human rights. Now, this in a way is building on Neil Gunningham and Darren Sinclair's concept of smart regulation, which is talking about involving the public sector, the private sector, and the public through a mix of regulatory instruments. The focus on international and domestic measures is really quite interesting from the perspective of AMR, because AMR is, of course, a global bad, but AMR in the environment is not just a local problem. Because in the short or the medium term, of course, the victims are the environment and the individuals and communities who live near these pharmaceutical manufacturing units. But in the long term, the adverse effects of AMR in the environment could be experienced in other parts of the world. This is because of the cross-border movement of antimicrobial resistance, for example, through people or through goods and other products. Therefore, the responsibility to address the emergence of AMR in the environment is not confined to domestic actors. It extends to other actors, including the beneficiaries of the manufactured products, that's pharmaceuticals that are being manufactured in these pharmaceutical manufacturing units. And this responsibility extends to the suppliers, to the buyers, and the consumers in other countries as well. So my paper broadly is focusing on what are the existing multi-level institutions and regulatory instruments for ensuring the accountability of corporations, and also considering the extent to which these institutions and instruments recognize the human rights, elaborate these rights and corresponding obligations, and identify consequences of violations, either explicitly or by implication. So I'm interested in whether regulation exists. If it exists, is it exhaustive? And whether it is being implemented. We know that at the international level, we have a range of human rights which are relevant for the perspective of looking at human rights violations from the emergence of AMR in the environment. The right to life, health, and food is recognized in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights in the case of the right to life and food, but also the ICE-SCR. The right to health is similarly recognized in the International Covenant on Economic, Social, and Cultural Rights. And we also find references to some of these rights in the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW, and the Convention on the Rights of the Child. The right to water and the right to environment are interesting ones because, as we know, that they are not explicitly recognized until the statements from the UN, but they are read into the right to health. And if you look at the general comment number 14 and general comment number 15, we find that there are a number of illustrations and examples of potential violations and of state obligations that provide an entry point for consideration of AMR in the environment as an example of violations of human rights. So, for example, the fact that an adequate amount of safe water is necessary to prevent death from dehydration, to reduce the risk of water-related disease, and to provide consumption, cooking, personal and domestic hygienic requirements in GC15 provides an entry point for consideration of these issues. We know that general comments are authoritative guidances, and although these examples are not exhaustive and illustrative, they do demonstrate that it is possible to incorporate measures to address the emergence of AMR in the environment because of the discharge of antibiotic effluent by pharmaceutical corporations. This takes me to the corresponding obligations of the state. We know that in Article 12 of the International Covenant on the Economic, Social, and Cultural Rights, there is a mention of preventing threats to health from unsafe and toxic water conditions. Now, this feeds in with the obligation to protect, which requires states to take measures that prevent third parties from interfering with human rights guarantees. This is another avenue for addressing some of these human rights violations that might result from the discharge of antibiotic effluent into the environment. In addition, I also wanted to draw your attention to the UN Special Rapporteur on Human Rights in the Environment's proposed 16 framework principles, where one of the principles said that states should ensure the effective enforcement of their environmental standards against public and private actors. So the sum of it is that there are opportunities within international human rights law, in addition to some of the other frameworks in development that were discussed in yesterday's presentations, to address some of these concerns. In addition to the international human rights framework, we can also look at some developments with respect to antimicrobial resistance directly. So for example, the World Health Organization adopted a global action plan on antimicrobial resistance in 2015, which urges national governments to develop national action plans that are aligned with the global plan. The action plan identifies different pathways for the emergence of AMR, and this includes the environment. The action plan also calls for international action and coordination. Although environmental concerns form a part of the action plan, they have received much lesser attention than the emphasis on AMR in human beings and animals. Another interesting development at the international level is the growing calls for the development of an AMR-specific instrument that will be responsive to the needs and capacities of different countries. This could potentially offer another avenue where AMR in the environment and the impact of the discharge of antibiotic residues from pharmaceutical manufacturing units into the environment specifically could be considered. The other element, in addition to the international regulation, is of course domestic regulation. And Rosemary identified some of the features of this regulatory framework in Kenya, and I use the example of India, which is one of the two countries besides China, which is one of the big producers of pharmaceuticals. So the first question at the domestic level then is whether these human rights are recognized at the domestic level. The Constitution of India recognizes the fundamental right to life, but not the other rights to health, food, environment, etc. These rights have been read into the Constitution as a result of the Supreme Court's efforts. The domestic environmental laws in India as of now do not address any standards for antibiotic residues. A draft was circulated by the government of India, but the final standards that came out as a result do not include anything about antibiotic effluents. So another opportunity to consider then is the role of buyer countries. What I mean by this is public procurement laws and policies in countries that are purchasing pharmaceuticals from India and China. These countries could include environmental criteria in their public procurement laws, which could then provide the incentive for pharmaceutical corporations to not engage in practices that could result, for example, in violations of human rights, including the right to environment. I see a message that says I have a minute left. I thought I had a bit longer, but I'll just try to wrap this up in the next minute and a half, if that's all right. So the final point that I want to make was about alternative regulation. So we are not talking about international or domestic regulation arising from the state, but regulation that might come from the pharmaceutical sector itself. So voluntary or self-regulation. And we know that the production, trade, and consumption chain of pharmaceuticals is complex and it involves many actors. So you have branded producers, generic producers, subcontracted producers of active pharmaceutical ingredients. In order to have this transparency in the supply chain, to ensure that there is disclosure of the identity and the geographic location of these producers, some of the efforts that are being made are coming from organizations such as the Pharmaceutical Supply Chain Initiative and the AMR Industry Alliance. In addition, certification systems are being developed in countries which could provide another avenue for consideration of environmental and social criteria, which could then address this concern of violation of human rights as a result of discharge of antibiotic residue. So to conclude this very short presentation, I just wanted to make two main points. The first is that AMR regulation is imperative and it requires a very coordinated response from state and non-state actors at multiple levels. In this case, from the host country, the procuring countries, and pharmaceutical corporations. And the second point is that while law can facilitate the distribution of responsibility for this global bad among different actors, it can also undermine this distribution of responsibility. This can be because of tension between laws, so protection of environment versus protection of free trade in the case of public procurement laws. It could be tension between laws with the same objective. So think about the right to health, which requires greater access to pharmaceuticals, but the right to health, which could be violated because of the discharge of antibiotic effluent into the environment, and also the tension between rights. tension between, say, the right to health because of access to pharmaceuticals and the right to environment, where we need to protect the environment itself as a good.
Okay, great. So we're going to be talking about shale gas or fracking development and human rights impacts in China. So first, the aim of our presentation is to highlight the current policy landscape for hydraulic fracturing, or fracking in China. And our focus in this case is really on the role of public perspectives and attitudes towards shale gas in China. And the purpose of this is really to highlight what existing data shows about current stakeholder understandings and perceptions. And importantly, we highlight that there's a great need for further research on public perspectives and responses, particularly in a non-democratic society, both for the potential protection of residents who are affected by the technology, and also for the data that can be contrasted with public perspectives and engagement in other countries. And this is particularly important both within the context of China's recent push since starting really in 2010, but increasing in importance is the push from coal to gas, which has led to an increased demand in natural gas, increased natural gas production. And within this context, China has the largest shale gas or unconventional gas resources in the world. And I think particularly as many other countries are starting to look at extracting shale gas, I think this research, though limited and kind of by definition limited because neither of us are Mandarin speakers, I think there's great value to looking at perspectives, particularly in the context of the wider availability of research and scholarship on public perspectives, Western public perspectives towards shale gas. So because of this, the findings are very limited, as this is preliminary research. Is that, Karen, are you able to?
I'm here. Can you see me?
Oh, okay.
I'm here.
Yes.
I'm on my phone because I don't know what happened to the computer, but I'm happy to take it from here, but you will have to change the slides for me.
Perfect. Yeah, that's fine.
Okay, so I don't know if anyone can see me. I have no idea. I can see you, Miriam, but I will just...
We can see you. Yes, this is great.
I say thank you to Ricardo, and it's been really lovely to sit in and indulge in these talks over the past day and a half. So thank you very much. I don't really know what Miriam has been talking about because I had to disconnect my device, but if I repeat myself, apologies. So Miriam and I worked together on regulation of fracking and public participation, accountability, social licensing, and we also ran parallel research on citizen science in China, and that led to the development of a preliminary study on fracking and China. And we focused our study on attitudes towards shale gas in China. And our goal was to shed light on what existing data shows about current stakeholder understanding and perceptions. And we highlight the need for further research on public perceptions and responses in a traditionally non-democratic society, both for the potential protection of citizens and stakeholders who might be affected by technology, but also in relation to attaining research data that can be contrasted with public perspectives and engagement in other countries, because we realise a lot of the discussions are very Western-centric. A lot of studies we found were based on the USA and Europe, and there was not much of available for comparison in relation to other regimes. It's very preliminary research, but we take the position that human rights and related elements such as public participation, accountability and decision-making very much centre around regimes. We also take the view that forward-thinking or ex-ante conditions that are in place are very valuable if human rights are to be acknowledged and implemented going forwards in relation to the development of natural resource projects. We had limited findings due to this being a very preliminary study, and we found that there were very mixed views about authoritarian environmentalism in China. And some of the reasons for that are expanded upon later in this presentation. we found people were quite frustrated by the lack of environmental progress in liberal democratic states, and some commentators speculate that authoritarian environmentalism is a possible route for effective governance, though more research needs to be undertaken on that. Switch slide, Miriam. So our theoretical framings are extremely cognizant of the fact we approach this from a very Western-centric position. We are not Chinese. We have not lived the experience of being a Chinese citizen. But we do take the position that Chinese regulators now have a chance to slow down the drive to frack and reflect on some concerns associated with fracking that have arisen in the USA and Europe, and that Chinese regulators can learn from best and worst practice. We were interested in using fracking as a case study because China is currently going through a transition where it has started as an authoritative regime to take a very proactive environmental protection position, and the regime, while still being top down, has started to roll out programs where they relinquish more power and decision-making power to local governance, and this is quite groundbreaking. And there have been examples of projects where this has been quite successful, particularly in relation to cleanup of dirty water bodies. And it's not a full relinquishing of control, it's still authoritarian, but it is spreading the workload in a way, and geographically and politically. So in relation to the example I mentioned about water, there have been a lot of state-controlled citizen science projects where there has been a big push to collect data, gauge opinions, engage the citizens, which brings about some form of enlightened thought and education, which is quite radical for China. And it has had good results in relation to the actual environmental impacts. We focus on governance and regime change, and we address procedure, accountability and social license. And I know that Egosa is going to talk about social license, so we will not go into so much detail about that. But in the West and fracking examples, we know there have, even though legislative procedures have been followed, and compliance has been met in relation to environmental impact assessment or health and safety regulations and the licensing of fracking sites, there has still been objections to those sites for wider normative and cultural reasons outside the scope of the regulatory mandates in place that have led to this a concept or expansion of a concept around social license, and that is something the Chinese authorities might consider in the future. We observe a connection of environment to an environmental regulation and human rights regulation inherently to politics and economics in this space. And we do offer our insights from a pro-environmental, pro-public lens for ex-ante considerations. This is what we work on, and we have to acknowledge our bias in that sense. And we observe public protest and social licensing in the West, as I've already said. Next slide, please, Miriam. So preliminary data was collected during a research trip to Beijing in 2017, and our findings were extremely limited, but we thought it was much more sensible to try and gauge opinions from people on the ground living the experience in China rather than try to speculate from an office in London. We do acknowledge limitations in our research in that we pretty much only had access to people of a certain social demographic, educated, informed, city people, and we would need to contrast our research in that sense with a wider study and wider demographic stakeholder group. To counter for that, we did look at existing research by Cher and Liu to try gauge insights into the opinions of rural villagers as well as city dwellers in relation to fracking, and we found some definite contrasting views in relation to how they viewed not only the technology and the environmental impacts, but also the governance system. So our research demonstrates the need for further investigation and understanding of perceptions of shale gas in China And we are beginning to look at expanding our research in that sense. So next slide, please, Miriam. The background to this, the cultural and political landscapes, as I've alluded to, of China are unique and vastly different to our Western systems and perspectives. But we see this case study as a good opportunity for Chinese governance systems to take a more proactive approach to the implementation of human rights in relation to accountability, public participation, education, and the expansion of including certain groups in decision making. The consequences of fracking are of a global concern. So we had an interest in looking at different countries and views in relation to the broader climate change agenda. Many dissenters argue that fracking is not a good bridge fuel. Obtaining the fracking gas releases a lot of methane, and there are serious consequences for global warming. In many Western democratic nations, that's something that is well known and discussed. We found that in China, it was not so well discussed. Next slide. In terms of limitations to the study, as I've already alluded to, most fracking studies are from North America, and a lot of fracking data views the technology positively. There are so many reasons for that. You have widely spread populations, landmass. Fracking sites are in the middle of nowhere. They're not near homes. They're not near villages. You have a different economy, more equity in relation to wealth, etc. So we argue there's definitely more a difference in the cultural systems we researched. So our concerns in relation to actual human rights issues in any country are in relation to lack of due process, lack of accountability, environmental and health impacts, and global climate warming. The human rights that are obviously impacted by fracking in relation to the process and the consequences are listed as follows, and that is not an exclusive or exhaustive list, but includes the right to life, the right to health, the right to water, the right to food, the right to housing, the right to access to information, the right to public participation, the right to a safe, clean, healthy and sustainable environment, the right to self-determination, and even the right to the security of person. Inequity and injustice arguments around energy, health, procedure and environmental justice do arise in the context of fracking, as they do with most of the natural resource exploitation activities. It tends to be the marginalised, the poorer, the less educated that are vulnerable to the impacts of these technologies and techniques, and they are less likely to be the beneficiaries of these endeavours. Next slide. So China was chosen as a case study because there was the opportunity to go to Beijing. We don't focus on the regulations in China, but rather we focused on the public's views of shale gas extraction. We had limited available literature. It's either non-existent or it's in Mandarin. And so we could not fully immerse ourselves into the whole range of developments in China. What we do know is China is emerging as a player in the international environmental arena, and they are able to leapfrog the adverse greenhouse gas emitting technologies, including fracking, and progress straight to clean tech. China can evaluate the extent that citizen support or rejection might play in the government or industry developing this sector. And we explored that further. Next slide. So environmental accountability and openness is slowly transforming. China has been developing 5-year plans. The leadership has changed. And I think because China is much more visible through social media, through the globalized information sharing systems, they are changing the way they administer and make environmental decisions. So there are opportunities here for regime change in China and opportunities for China and the other countries to learn from each other. Next slide. So in understanding public perspectives, we wanted to gauge public views through, as I said, interviewing. We contrasted our experiences through researching in the UK with what might be happening in China. In the United Kingdom, for example, we have a democratic system, governance structure. We have implemented most international human rights agreements. We are very good on paper, but in practice, in relation to the case study of Lancashire in the United Kingdom with the quadrilla application, we noticed some kind of sidestepping or obfuscation of obligations that you would expect from democratic decision making. For example, the Lancashire County Council did not approve the fracking at the Preston New Road site for quadrilla. There was a big public inquiry. The majority of views were against the fracking, and the local council, following legislative processes to open up the decision making to the public, to have public meetings and surveys, etc., agreed not to license the site. That decision was called in by the Secretary of State for Communities in the interests of national security. No real reason was given for that, and there was a huge uproar in and amongst the local communities that were going to be affected by the fracking, which is interesting because it highlights that we have on paper a really good track record with decision making and accountability, but when it actually came to enforcement, the government just did what it really wanted to without providing a real legitimate reason. An oblique reason as being in the national interest and of security was the reason given. So we were interested in China to teach some lessons, not what to do, and also to learn from what China may be doing well that the UK could also learn from. Research has highlighted internationally in most case studies that assessing public opinion as well as the divergence in public opinion before fracking is approved is central to obtaining social license and public buy-in and in assuaging and educating the public. And that is extremely well connected to the implementation of the aforementioned human rights. Next slide. So access to information and repression of environmental-based challenges in China is changing. China regulation, there are Chinese regulations now on open government information. There are regulations that allow cases to be brought to court, and progress is being made in relation to activism. We gave an example at the beginning of this talk about the progress in black and smelly waters and the engagement of citizens. So there is an increasing role and engagement of citizens throughout China as a nation. Next slide.
Karen, if I could just ask, maybe a couple more minutes, please.
Miriam, I think it's time for you to speak anyway.
Okay, I will speed through this as quickly as possible. So as mentioned, the demand for natural gas in China is increasing, particularly in 2021. Over half of natural gas in China, consumed in China, came from domestic production, and of that, nearly half was from unconventional sources such as shale gas. And as mentioned, this is in large part because of China's coal to gas transition in order to reduce pollution. So there's a great growing demand for natural gas in China, among other climate change concerns and challenges. In terms of public perspectives in China, there's, as mentioned, there's little known about the impacts of shale gas and how fracking impacts local communities, particularly rural communities. And this is largely because of the lack of research, the greater amount of research on Western perspectives, and also the limited understanding of impacts in rural communities, particularly with language barriers. So in terms of the need for further research, unless China can enforce robust regulations specific to unconventional shale gas development, these efforts to reduce air pollution can shift health, safety, and environmental risks to rural areas where shale is being developed and threaten the livelihoods of local communities. So a number of studies highlight gaps in available data. I'm just going to skip to our results here. So in terms of the interviews, these were semi-structured interviews conducted to identify issues and then in order to identify directions for future research. The interview design was meant to be open-ended to help prevent, to the extent possible, bias and imposition of Western-centric perspectives. And so these preliminary interviews, there were 36 respondents in Beijing who replied to a number of basic questions on their view of shale gas. And the concerns were impact on general environmental quality, water contamination, emissions, and then benefits cited were, the number one benefit cited was good as a replacement for coal and potential economic or developmental benefits. So in terms of our preliminary findings, this was, as mentioned, a skewed study in the sense that these were respondents who were able to respond to interviews in English, and they were university students or researchers from the wider Tsinghua University network. So there is an inherent bias there, and at the same time, I think value in understanding the perspectives of a subset of the population. So here's just a table that highlights the supporter opposition, the main issues mentioned. And respondents in our preliminary research seem to view shale gas as a better alternative to coal, but still had some significant concerns related to environmental and water issues. And just to wrap up here, in terms of conclusions and future research, I think that there's an important role for access to information and education, and this is something that's particularly highlighted in our preliminary findings. We also found that there's a great rural versus urban variation in the way citizens are both aware of issues and view potential sources of energy. And finally, we think that there are some exciting opportunities for citizen-driven monitoring and citizen science. As Karen mentioned, success stories with the dirty and smelly waters and other similar projects that are using the great wealth of citizen understanding of environmental issues and can help with accountability. Thank you very much.
Many thanks. It's an excellent double act, and thanks for your flexibility there also, Miriam and Karen. Next up, we have Dr. Akoza Akator. He will present on social license and the social license and the promotion of socio-economic rights in the extractive sector in Nigeria, a critical assessment.
Thank you very much. I think, yeah, Miriam's slide is still appearing on the screen as well.
Oh, yeah, thank you. Miriam, could you actually, or can I do it? It's just the, and yeah, perfect. Great, thank you.
Thank you very much. I'm not going to share, I have a slide, but I'm not going to share my slide. I was just run through what I'm going to discuss today. My topic for today is social license and promotion of socioeconomic rights in the extractive sector of Nigeria. And thank you for inviting me to this very important workshop. The perspective around this paper is that social license, which is the unwritten agreement between MNCs and oil communities, plays a very important role in the promotion of socioeconomic rights. And my view is that the activities of MNCs through their localization of international soft law conventions or CSR initiatives can be a way to promote socioeconomic rights in countries where socioeconomic rights are not justiciable or enforceable. So these are preliminary thoughts on this paper, and I'll be glad if I can get comments to develop it further. So in this paper, we are discussing the definition of social license, the negative impact of the activities of MNCs on human rights of people living in Niger Delta in Nigeria. So Professor Gunningham defined social license to operate as the demand and expectations for business enterprise that are made from neighborhoods, environmental groups, community members, and other elements of the surrounding civil society. Professor Efron in 2018 defined SLO, which is social license to operate, as an unwritten agreement between the company and communities or stakeholders in which society support is required to enable the company's legally granted operations. The SLO is in addition to the legal or environmental permit or license granted to the energy company by the mineral landholder. So thus, a multinational corporation with a social license is deemed to be legitimate and accountable to the government and other stakeholders. So this is very, very common in Nigeria, especially when in the oil and gas sector, especially in Ogoniland, where Shell has got a very bad reputation in terms of, for more than almost 30 years, Shell has not operated in Ogoniland. They've not operated any of their equipment. Even though Shell has got CSR initiatives in Ogoniland, in Niger Delta, they cannot operate in that area because they've lost the confidence of the people. They've lost the social license that emanates from their relationship with the people of Ogoniland. So the idea is that a company may have the legal license, but if you don't have a social license, at the end of the day, your activities may not end up to be legitimate or credible. So in the Niger Delta, for example, CSOs, civil society groups, have a very long history of protesting the activities of the oil industry, the activities of the movement of survival of Ogoni people, MUSOP, which was led by late Ken Saro-Wiwa in the 1990s, changed things radically because the MUSOP was able to mobilize Ogoni people to identify with and support his cause. So furthermore, due to the impact of Shell's activities on Ogoniland and his alleged collusion with Nigerian authorities in a trial, conviction and murder of Ken Saro-Wiwa, who was one of the leaders of Ogoniland and one of the founders of the MUSOP civil society group, the people of Ogoniland rejected Shell and withdrew its social license by protesting and mobilizing against Shell for more than 30 years. So for almost 30 years now, Shell has not operated any of its facilities in Ogoniland. So therefore, the Shell Ogoniland community revoked the social license of Shell to operate in the area of operation of Ogoniland, notwithstanding that under Nigerian laws, Shell has the right to operate in the region. So while other ethnic groups in Niger Delta brought the MUSOP template to organize the protest, the federal government's high-handed response contributed to the rise of militancy as a means of further protest in Nigeria. So that's just the background to social license definition, and how it plays an important role in the way oil communities conceptualize their relationship with multinational corporations in Nigeria. So the other slant of the paper talks about socioeconomic rights in Nigeria. Ordinarily, in Nigeria, there's the argument that socioeconomic rights are not justiciable or enforceable in Nigeria. This is premised on Section 20 of the Nigerian Constitution, which seeks to promote and protect the environment. Section 20 of the Nigerian Constitution talks about environmental protection, but it's found in Section 2 of the Nigerian Constitution. And under Section 2 under Chapter 2 of the Nigerian Constitution, rather, issues and pronouncement in Section 2, in Chapter 2 of the Nigerian Constitution, are neither enforceable nor justiciable. Because of this lack of access to right to environment being justiciable is a major hindrance to access to environmental justice by victims and stakeholders and NGOs in Nigeria. So although the prevailing view is that Chapter 2 of the Constitution, where you find right to environment provisions in Nigeria, is non-justiciable, there are some writers who contend that this is not the case, that Chapter 2 is justiciable or can be made justiciable. I believe that right to the environment is justiciable in Nigeria. That is my view, and enforceable. And it also must be pointed out that some Nigerian courts have consistently said that socioeconomic rights are not justiciable in Nigeria. But recently, in 2019, there's a recent Nigerian Supreme Court decision which states that right to the environment can be made enforceable and justiciable in Nigeria. Also, Nigeria has also domesticated the African Charter of Human People's Rights, which recognizes the right of all people to right to environment on the continent. So in 2019, the Nigerian Supreme Court in the Center for Oil Pollution Watch and Nigerian National Petroleum Corporation held that environmental NGOs in Nigeria have the local standard, have the standing to institute environmental cases in Nigeria, thereby improving access to environmental justice and promoting sustainable development for litigants, victims, and communities in Nigeria. So a lot of people have said that this decision of this oil pollution case will lead to a floodgate of cases in Nigerian courts. And my view is that this judgment will enable environmental NGOs and CSOs to institute cases, including on behalf of victims of environmental injustices in Nigeria. On the other hand as well, furthermore, this recent decision by Nigerian Supreme Court can serve as a launchpad to further develop the evolving jurisprudence around socioeconomic rights in Nigeria. So, and also in that case as well, the Nigerian Supreme Court mentioned that right to the environment can be justiciable and enforceable in Nigeria. So that's one aspect of my presentation. So the other aspect talks about the impact of multinationals on human rights in Nigeria. You have negative impacts on human rights of local communities and people living in Niger Delta. You have issues around right to food, right to housing, issues around oil spills affecting the waterways, affecting streams, oil spills destroying the farmlands of the people living in Niger Delta. So the activities of the operations of multinational corporations have had a negative impact on the human rights of people living in the Niger Delta. So human rights violations are no longer associated solely with governments, but also with multinational corporations. So many reports have documented the negative impact of the activities of multinational corporations on human rights in Nigeria. Some of the documented abuses of violations alleged to have been made by MNCs in Nigeria include abuses ranging from health and safety violations in the workplace to murder, to torture, to forced displacement at the hands of the military and security forces protecting company facilities. And some of the human rights violated by multinational corporations in Niger Delta include right to environment, right to life, right to health, right to food, right to water, right to culture, right to property and housing, right to private life, and right to dignity of persons, amongst others. So this is against the backdrop that the uncertainty surrounding the justiciability of socioeconomic rights in Nigeria. So how can we make MNCs to respect and promote human rights in Nigeria, especially socioeconomic rights? So that is why the importance, the relevance of social license as a regulatory tool, as a societal tool, as legitimacy tool can come into play in trying to hold MNCs accountable. So how can we implement socioeconomic rights through the prism of MNCs activities in Nigeria? My view is that MNCs have an important role to play in the implementation of socioeconomic rights in Nigeria, especially in Niger Delta. The idea is that this can be done in two ways. This can be done in localization by MNCs of international soft law mechanisms on the regulation of MNCs, on CSRO on the international plane. Also, the use of CSR initiatives on the ground itself can also be used to promote socioeconomic rights related activities. So basically, my idea is that the MNCs have an important role to play in the implementation of socioeconomic rights in Nigeria, especially in Niger Delta. This can be done, one, use of international soft law mechanisms, two, the use of CSRO initiatives in the Niger Delta. So how can they do it in terms of localization of international mechanisms? Some MNCs in Nigeria have actually localized some of the international mechanisms, such as the Ruggie Principles and similar mechanisms, into their codes of conduct. For example, Total Security Environmental Report of 2011, the Total seeks to promote equal pay between sexes, claims to be responsible corporate citizens, and states that in 2011 it trained more than 35,000 employees in its anti-corruption e-learning program. Also, in its code of conduct, Total seeks to localize the core of the Universal Declaration of Human Rights, ILO conventions, OECD guidelines, and the principles of Global Compact in its operations. One of Total's general principles is to continuously uphold respect for human rights standard within a sphere of activity where it operates. So in that way, by MNCs talking about socioeconomic rights in their codes of conduct, and MNCs trying to actually localize socioeconomic rights in their day-to-day activities in Niger Delta, that could be one way to implement socioeconomic rights in Nigeria. Also, social license as a strategy for promotion of socioeconomic rights. MNCs operating in the oil and gas sector of Nigeria have engaged in a series of initiatives to enhance community development in the Niger Delta. This is anchored on the premise that if oil MNCs can contribute to community development via CSRO, it will help to address local grievances, improve community development, and promote positive corporate community relations. Many oil MNCs and other companies are involved in plethora of CSR initiatives in the Niger Delta and other parts of Nigeria. CSR initiatives in Nigeria may include building of schools, hospitals, markets, provision of pipeline water, amongst other initiatives. Nevertheless, the extent to which these CSR initiatives have contributed to the community development in the region remain contested. And also, we also need to be aware that CSR is mainly voluntary in the oil sector in Nigeria. However, many MNCs now utilize MOUs as a means of realizing CSR in the Niger Delta. So those companies in the CSR initiatives in Nigeria to obtain social license. So those companies engage in CSR initiatives to obtain social license to operate in community or regions in Nigeria. MOUs are also referred to as examples of community development agreements. So one way to implement that could for MNCs to actually in a way ventilate their CSR initiative from the prism of socioeconomic rights. So as one way of mitigating the negative externalities arising from the activities, MNCs have relied on the use of CSR initiatives such as MOUs and GMOUs. Also, on the other hand, we can also think of Dr. Wampi suggests that social license should be localized or codified in the formal legal system in Nigeria. Notwithstanding the criticisms of CSR initiatives in the oil producing communities in Nigeria, some scholars, including Lampo and Trani, have argued that CSR initiatives of oil MNCs have enhanced access to basic capabilities like shelter, water, and electricity, but have also weakened human development. Hence, MNCs are also said to promote skills development in Niger Delta. Udoji in their paper in 2020 have argued that GMOUs and MOUs have generated significant reductions on key drivers of resurgences in Ogoniland. Even though Shell is not operating its machines or equipment in Ogoniland, it has maintained its community development venture and programs in Ogoniland. Also, CSR initiatives can also be one of the strategies to implement. CSR initiatives can also be one of the strategies to implement SDGs in Nigeria, and many of these SDGs are interlinked with socioeconomic rights. Also, private sector and businesses have an important role to play in the actualizations of SDGs in the country as well. So, finally, multinational corporations have a big impact on the world, not just on the economy, but also on the environment and society. From oil spills to child labor, companies' activities and mistakes can impact people and the planet. This means that MNCs have a responsibility, but the question is, are MNCs living up to that responsibility? So, however, the reliance on international mechanisms, codes of conduct, self-regulation, CSR initiatives provides opportunities for MNCs to mitigate the negative impacts of their operations and activities in developing countries, including Nigeria. Finally, MNCs can provide other strategies to implement socioeconomic rights in Nigeria. So this presentation suggests that social license to operate should be codified in Nigerian laws to enhance the legitimacy of CSR initiatives run by various MNCs in Nigeria. Finally, the implementation of socioeconomic rights is also vital to the realizations of sustainable development goals in Nigeria. Thank you. That's the end of my presentation.
To introduce myself, I'm Bernadette Rainey, and I'm a senior lecturer at Cardiff School of Law and Politics, and I'm also director of Human Rights and Public Law Centre. And the speakers today are, for this panel, are Dr. Lee McConnell from University of Bristol Law School, and Lee is going to be talking about natural resource extraction and the business of human rights treaty and prospects for that. And then we will have Annalisa Sarvarese from University of Eastern Finland, Claire Mevin O'Brien from University of Dundee and the Danish Institute for Human Rights, and Marissa McVeigh, Dr. Marissa McVeigh as well, who's an alumni of St Andrews and is working for the Northern Ireland Human Rights Commission. And I'll say a bit more when I introduce them, I suppose. And it's Marissa and Annalisa who are given the paper today. So I think, and Ricardo can correct me, that in terms of answering questions, you can ask on chat, and I think I probably can unmute you as well if you want to ask a question. But again, if that's not right, Ricardo, let me know.
That's absolutely right, yes.
Yeah, that's right. Thanks, Ricardo. So I think we'll make a start then. I will attempt to time this part. Hopefully I get it right. I've got a little note, Lee, for 5 minutes, and 2 minutes roundup after 5 minutes, if, just to remind you on the time. I'll just keep an eye on that myself. And then obviously we'll have the discussion after. So I'll hand over to Lee, who, as I say, there's obviously a common theme today in this is the idea of a human rights and business treaty. And so Lee is going to talk about that in terms of natural resource extraction. So Lee, I'll hand over to you then.
Yes, thank you so much, Bernadette. Let me just share my screen. I hope that this works, and please let me know if it doesn't.
Yep, it's working.
Lovely stuff, thank you. So thank you so much for that introduction, and thank you to Ricardo for organizing this fantastic event. It's so great that it's finally happened. We've been waiting for years, and I've learned a lot from the sessions both this morning and yesterday already. I've refined the focus of my paper a little bit, so I'll still speak about resource extraction and I'll still speak about the Business and Human Rights Treaty, but I want to do so in the slightly more specific context of human rights impacts produced by the interactions between extractive industries and the security forces of foreign states, which is part of a project that I'm just at the very start of working on with Jane Rooney from Durham, who spoke yesterday. So today I want to draw on a recent case called Cadi Calma to assess whether the treaty is responsive to this long-standing problem. You may have heard of the case. It was a civil action brought against the owner-operator of one of the largest iron ore mines in Sierra Leone. And as is very common, as we've heard, the mining activities produced tensions with the local community, who complained that the company had dispossessed them of their lands, contaminated their water supplies, and generally failed to meet promises concerning infrastructure development. The case itself centered on events in 2010 and 2012, where local communities had erected roadblocks delaying and detaining company workers. So in 2010, the police arrived and arrested several individuals and transported them in company vehicles to the mine site, where they were detained and severely beaten. And then in 2012, 200 police responded to striking workers and local communities by firing live rounds and deploying tear gas and killing one person and injuring several others. In terms of evidence that was disclosed, the company was found to have made substantial cash payments to the police with knowledge of the corruption throughout the police force, to have accompanied the police, to have lent them vehicles owned by the company, to have provided the police with accommodation at a guest house, and to have given false testimony regarding certain events. There was also an email disclosed from the company's community and social manager recommending that the local government treat the population in a, quote, sort of Stalin-like fashion, adding in brackets, not quite. So really terrible stuff that was disclosed. And in spite of all of this, in all instances, the court marshaled these facts to the favor of the company. So the court found in favor of the company in all instances. The company was not an accessory to the tortious conduct by the police, and the company had provided, quote, pragmatic incentives and not bribes to achieve tortious ends. Any financial and other support by the company was intended to assist the restoration of law and order and not to incite unlawful conduct from the police. And no direct duty of care on the part of the parent company could be established, despite the company making reference in its soft law, in its annual statements and reports, making reference to soft law instruments on security and human rights, holding itself out as doing so. If we think in terms of Vedanta, though obviously this is a little distinct, and maybe we can talk about that in the discussion. So in view of the reluctance of the English courts to establish civil liability in this situation, can the draft treaty on business and human rights provide a corrective? So As with previous versions of the treaty, the 2021 draft imposes obligations on states alone to ensure through their domestic legal systems that businesses respect human rights. And Article 6 is key in this regard on prevention. It requires states to regulate effectively the activities of business enterprises within their territory, jurisdiction, or otherwise under their control. And they must adopt legal and policy measures to ensure that business enterprises, including transnational enterprises, respect human rights and prevent and mitigate human rights abuses occurring throughout their business relationships and activities. So the scope of these terms is quite crucial to the treaty itself. They're defined in the treaty in Article 1.2. A human rights abuse is any direct or indirect harm occurring in the context of business activities. So this seems broad enough to capture scenarios where state agents are the primary wrongdoers, but it's limited to those arising in the context of business activities, defined as any economic or other activity, including, but not limited to, the manufacturing, production, etc., of goods and services. So this raises several key questions. Will the notion of a business activity extend to situations in which, in the view of the English courts, a well-meaning property owner simply calls for assistance from the state police who are in no way directly or contractually connected with the goods and services of the company in question? Does the informal provision of funds, accommodation, facilities, transport, etc. by the company to an operationally independent police force to support their public functions, does that establish a business relationship? And does the mere fact that only some of the victims were company employees bring this into the sphere of business activity? So as I say, these terms are central to delimiting the scope of the state's obligations under the treaty, and this will in turn impact on the framing of any resulting domestic regulation. They're key to operationalizing the concept of human rights due diligence within the treaty, as you can see in Article 6.3. And while provisions like this are likely to be responsive to activities undertaken among parents, subsidiaries, contractors, and even purchasers and suppliers, it's less clear how far they will go in relation to state agents with whom companies are engaging in an indirect, non-commercial and non-contractual fashion. So, I think crucial to this is clarifying the relationship between the treaty and the UN guiding principles on business and human rights, because the language of activities and relationships is shared with that instrument, which could be good from the perspective of coherence. But we know that, John Ruggie was keen to emphasize that the guiding principles consist of social norms and don't correspond with pre-existing legal categories, which suggests that there could be translation problems between these various instruments. So, assuming that the guiding principles can be used as an interpretive aid to the treaty, guidance on how the principles should be interpreted state that business enterprises may contribute to gross human rights abuses that are committed by other parties, e.g. security forces, and that enterprises may contribute to an impact through its own activities if they lend vehicles to security forces and use them to travel to local villages to commit atrocities. So if the context of business activities is given a similar meaning under the treaty, this will impose broad positive obligations on states to ensure that extractive industries take appropriate measures to avoid, prevent, mitigate abuses that they've contributed to, but are authored by foreign state agents. Nevertheless, there may also be other problems with, for example, Article 8 of the treaty, which concerns legal liability. Article 8.10 says that states must establish liability for acts and omissions that constitute participation or complicity in a criminal offence. And there's no corresponding provision relating to participation in purely civil wrongs. And indeed, the treaty makes it clear that civil responsibility should not depend on findings of criminal responsibility. So there's potentially a long-standing loophole in successive drafts in that connection. Secondly, under Article 8.6, states must establish liability for companies who fail to prevent another natural or legal person with whom they have a business relationship from causing or contributing to human rights abuses where the company controls, manages, or supervises the relevant person or activity, or should have foreseen the risk in their business activities and relationships, but failed to take adequate measures to prevent the abuse. Now, while it's unlikely that African Minerals controlled or managed the Sierra Leone police, it's indisputable for the courts that the harms were foreseeable. This provision, however, seems to be limited to third parties with whom the company has a business relationship. So Article 5.1 defines this as any relationship between persons, including state and non-state entities, to conduct business activities. This is more permissive than previous drafts of the treaty, which limited the term to contractual relationships. But it feels to me unlikely that the factual connection between African Minerals and the Sierra Leone police could be described as being established to conduct business activities. So further thought needs potentially to be given to these provisions. And in general, the treaty seems to frame the state as a good faith legislator rather than acknowledging the complex ways that they can be said to be directly involved in abuses. So while states will already have obligations regarding their security forces under wider international human rights law, a future draft treaty could restate these obligations for states to ensure that their own agents do not cause or contribute to abuses arising through their interactions with business actors. And future drafts could also obviously clarify and perhaps expand the scope of positive obligations on states to ensure that businesses undertake human rights due diligence and attract domestic liability where appropriate regarding their interactions with foreign state agents. However, there is potentially a set of further problems that arise from expanding these already broad positive obligations. For example, recent general comments by the Committee on Economic, Social and Cultural Rights regarding positive obligations on home states to regulate extraterritorial business activities have been met with skepticism in some quarters, with scholars arguing that such obligations rest on misframings of key principles relating to jurisdiction and state responsibility. I am inclined to disagree with this in most respects. First, it's questionable whether there's really any extraterritorial jurisdiction being asserted at all, given that home states are really only being asked to regulate the conduct of parent companies within their territory. And any domestic law would require parents to undertake due diligence assessments concerning their foreign subsidiaries, but not regulate in any direct sense the foreign entities themselves. And therefore, any domestic liability would arise from acts and omissions by the parents based in the home state. And similarly, any international responsibility for the home state would arise from its own acts and omissions within its own territory relating to its corporate nationals. Arguments that this type of regulation constitutes interference in the affairs of other states also seems tenuous, because globalization and economic integration means that virtually every legislative act or omission in one state can produce economic and other effects in another state. And to suggest otherwise is to frame inaction by the home state as neutral when it in fact maintains an environment where severe human rights abuses go unchallenged, and home state action aimed at promoting observance of human rights as interference. And that sort of argument just functions to sustain and reproduce the status quo by painting it as a kind of natural domain of freedom from interference when it is in fact pre-shaped, structured and constituted by particular understandings of public international law. Moreover, without completely going into the Lotus case, the basis on which states can exercise extraterritorial prescriptive jurisdiction are highly flexible and permissive, while existing human rights treaties often do limit a state's obligations to persons present in their territory or subject to control by their agents. There's nothing to prevent, in theory, states creating rights corresponding to a far wider class of beneficiaries. And while it does go against the status quo and perhaps self-interest short-term of some states, there's no doctrinal barriers to this because the concept of jurisdiction has no natural meaning or scope. And where a treaty does identify beneficiaries outside of the state's territory and control, they extend the sphere of a state's jurisdiction and enlarge the domain in which its responsibility can be engaged. However, there is a risk of states assuming obligations so broad that there's little possibility, practically speaking, of a breach ever being established. And this is me coming towards a conclusion on this point now. So while obviously territorial and personal control is not necessary in order to establish these extraterritorial positive obligations, they may be crucial to establishing whether inaction by a home state has caused or contributed to the violation of a substantive rights. And in the European Court of Human Rights jurisprudence, some degree of control, in addition to knowledge, capacity, and an appraisal of reasonableness, has been integral to establishing violations of positive or due diligence style obligations. And it seems, unlikely that the mere omission of a single home state to regulate an aspect of a parent company's conduct concerning overseas interactions between a subsidiary and agents of a foreign state could be said to have caused, a particular harm. And obviously, if it's impossible to prove violations of key provisions by home states, this is not going to do very much to incentivize the implementation of the treaty and compliance with the treaty. However, and I'm inching towards a conclusion, the positive obligations in the draft treaty are distinct from those in the European Convention on Human Rights and other treaties. For example, Articles 6, 3, and 4 contain a fairly detailed list of proceduralized sub-obligations spelling out what is expected of states. And so it may be possible to hold states responsible for falling short of some kind of objective standard of implementation, irrespective of whether their omissions have actually contributed to a substantive harm. That said, there of course will be difficulties in appraising the reasonableness or appropriateness of each state's regulatory measures and in establishing these objective standards of conduct in view of the margin of appreciation that must be afforded to states given their diverse legal and constitutional arrangements. So to conclude, while the treaty rightly, I think, focuses on the creation of robust domestic regulation and access to domestic remedies, it needs to be backed with a realistic form of residual international responsibility where appropriate. And in view of the Kalmar case, certain features of this draft perhaps risk reinforcing a status quo in which home states evade responsibility in international law. They continue to evade that responsibility. Companies continue to evade domestic responsibility in home states, and host states continue to be responsible in international law, just as they always have been prior to this Business and Human Rights Treaty, but there's very little in terms of enforcement mechanisms. So I'll leave it there. Thank you so much for listening.
Okay, thank you, Lou. That well timed as well. Really very interesting presentation. It throws up lots of thoughts and questions, I think, for after the next presentation. So the next presentation then is by Annalisa and Marisa, who have worked with Claire Meffin O'Brien on this paper on corporate accountability for climate change related human rights abuses, what role for UN business and human rights treaties. So hopefully there's some interesting stuff obviously to come out of this one, but also to link with what Lee said as well. Okay, so Annalisa, if you're ready to go then and screen your, yep. So just start whenever you're ready, Annalisa.
Thank you so much for the invitation, and it's great to be here. As mentioned by our chair, I will today be covering the topic of corporate accountability for climate change related human rights abuses. I teamed up with my friends and colleagues Marisa McVie and Claire O'Brien because they are both experts on business and human rights and have worked extensively in this area. Claire is not with us today, but Marisa will be doing the second part of the presentation, whereas I'll be talking about the first and specifically climate change related human rights abuses. This is incidentally work that is based on both a paper that I recently published with Joanna Setzer in a special issue of the Journal of Human Rights and Environment on rights-based climate litigation, as well as a forthcoming paper with a couple of colleagues from the University of Eastern Finland on mandatory due diligence laws and climate litigation. So a couple of words for those of you who may not know this yet about climate litigation. Climate litigation is on the rise, and it's a very fluid practice and concept. You can see the references in the bottom of this slide. There have been databases created even to capture this phenomenon since its origins in the 2000s. What is clear, and you can see from this diagram, is that climate litigation is on the rise. The 2021 column in this diagram refers only to the first half of 2021. So it's growing, and a lot of this is increasingly based on human rights. Now, what is important for us to appreciate is that the vast majority of this litigation involves states and non-state actors. So typically it's non-state actors like corporate or civil society or individuals bringing states to court. However, there is the theoretical possibility for interstate litigation. It's been widely discussed in the literature. We may have an advisory opinion from the ICJ or the ITLOS. We don't know. But the truth is that this is a scholarly hypothesis only so far. What is more interesting for our purposes today is the litigation that is being brought between non-state actors and particularly against corporations. It's important also for us to realize that this litigation is happening at the national level, therefore before national courts or quasi-judicial bodies like OECD national contact points. Some of this litigation concerning climate change is happening at the regional level, but none of this affects corporate actors, as we will see. And finally, of course, we have the possibility of international litigation involving international courts. Again, a scholarly example so far, but with time, we may see what happens. And if we are talking about international human rights bodies, for sure, some of this litigation is already happening. So as I said, corporate actors play a funny role in this picture. Why do I say that? In the early days of climate litigation, corporate actors were largely in the applicant seat, and they were challenging states for climate legislation typically and various measures adopted to address climate change. Not surprising, clearly, corporate actors were trying to defend their interests and therefore use the litigation to oppose legislation that was going against their interests. In recent years, however, there has been a spike in what we call pro-climate litigation, which is litigation aimed to support climate action. In this context, the tables have turned and corporate actors have started increasingly to find themselves in the defendant seat. So individual NGOs typically bring to court states, but most rarely corporate actors as well, in order to prompt them to take more ambitious climate action. So it is an evolving, as I said, fluid picture that we have before our eyes, but what is interesting to consider is specifically the role of corporate actors. And just so that we are clear, there is a difference in this table between human rights-based lawsuits and general climate lawsuits. When we're talking about human rights-based litigation, the vast majority of this litigation is clearly brought against states and only rarely against corporate actors for obvious reasons. Where is this litigation happening? It's clearly happening everywhere, but most crucially, human rights-based litigation is largely happening in Europe. There are a number of reasons that I can venture as a justification for this concentration, but I'm sure, assuming that all of you have heard of the famous Urgenda court decisions in the Netherlands. These court decisions have inspired other applicants across the continent to rely on similar arguments, which include human rights, in order to challenge state inaction. As we will see today, these arguments are increasingly being used also against corporate actors. So this is why Europe is leading the pack in human rights-based climate change litigation. When we're looking at general climate litigation, instead, it's North America that leads, but we have to be careful with these numbers because, as I said, a lot of this litigation, especially in the early days, was anti-climate litigation driven by corporate actors against states to prevent climate law and policy developments. So in the paper that Joanna Setzer and I wrote, we used the UN Special Rapporteur's articulation of the business obligations vis-a-vis climate change, the report that he published in 2019, and tried to unpack the way in which these obligations are used to articulate climate change related complaints. Those familiar with the report will already know that the special rapporteur, in a rather normative fashion, distinguishes corporate responsibilities between substantive and procedural, and talks about the positive duty to reduce emissions and support climate policy, and the negative duty to refrain from harmful activities. When we look at the 16 cases that Joanna Setzer and I identified in our research of pro-climate cases that target corporations, we discovered that the vast majority of these complaints ask corporate actors to reduce their emissions. However, at least some of these applicants also ask corporate actors to stop obstructing climate policy and instead to support it. It's fair to say that Joanna and I found limited evidence of complaints that asked corporate actors to refrain from harmful activities, and equally limited evidence of complaints that were based on procedural obligations or responsibilities concerning disclosure of emissions, consultation of affecting parties, and accountability and access to remedies. However, as I said, we had very few cases to go by, and we predict that the more articulate these obligations or responsibilities of corporate actors become, for example, through the adoption of due diligence legislation, the more likely it is that we will have more procedural complaints and more complaints associated with the other responsibilities that we see in this page. In other words, the law is in the process of changing, as we will hear from Marisa shortly. And we do think that the two developments will go in parallel. The more law we have, the more applicants will rely on it in the context also of climate change related complaints. And just briefly, I wanted to highlight for you the Milieu Defensie case that has been won, at least at the first instance level in the Netherlands. This was the first case of its kind. It's a case that builds on the famous Urgenda decision in order to initiate a lawsuit against Royal Dutch Shell, one of the so-called carbon mayors. What the applicants did was to rely on a blend of tort law and human rights law to argue that the corporation had breached its duty of care towards the applicants, and as such, the court should order the Royal Dutch Shell to reduce its emissions, not only its own territorial emission, but those of its value chain as well. This is an enormous landslide victory for the applicants. Of course, it's subject to appeal, and we have to see what happens. I have to say that it was not a given that the applicants would win. The leap between the same kind of argumentations vis-a-vis the state and vis-a-vis corporate actors is quite big. So the Dutch courts here really made a courageous and progressive step. It remains to be seen whether other courts in Europe will be willing to do the same as happened in the case of Urgenda, because there is similar cases pending, for example, in France, where, however, there is due diligence legislation that has been used. Very good. I think I'll leave the floor now to Marisa to do her share of the presentation and tell you what the treaty negotiations may do. So Marisa, I'll give you the floor and you just tell me where to click for the next slide.
Hi everyone, thanks so much, Annalisa. Can everyone see me? I'm not sure if I'm on.
Yep, I can see you, Marisha.
Okay, that's grand. Brilliant. So,
oops, sorry, I'm going too fast.
Speeding through it there. So I'm just going to give an overview of a general overview of the binding treaty on business and human rights, and then talk specifically about the environmental provisions, the kind of quite progressive and interesting provisions within the treaty itself, and then talk about whether or not this will actually enhance corporate accountability for climate-related abuses. So just to give you a kind of a general overview then, is that really, you know, the UN Guiding Principles were enacted or approved in 2011, but despite the dominance of the Guiding Principles over the past 10 years, civil society organisations and governments in many countries, particularly in the global south, have been insisting that these voluntary norms are not sufficient to hold businesses accountable. So in 2014, oh, there we go. Thanks, Annalisa. In 2014, then the so-called Ecuador Resolution 2069 was passed was adopted by the UN Human Rights Council. This established an open-ended working group on transnational corporations and other business enterprises, which elaborated on a legally binding business and human rights treaty. In 2018, then we saw the adoption of the Zero Draft Treaty, and since the beginning of the negotiations, they've been characterized by the opposition of several key states, including the EU, which has adopted kind of a tendency towards a very half-hearted approach in negotiations. In 2020, then we saw the second revised draft, which was published, and then in August 2021, the third revised draft, which I'm going to talk about today, was tabled, and this served as the basis of negotiations for the 7th session of the open-ended working group. And the current treaty builds, very much on internationally recognised human rights to clarify the precise obligations of states in relation to business activities. But as I'll talk a little bit more about, the negotiation is still filled with political and conceptual hurdles, none of which are simple to work out. Annalisa, would you mind going to the next slide for me? That'd be great. Brilliant. So as a very brief overview, the key elements of the third revised draft of the treaty is that there are no direct human rights obligations on companies. Instead, we rely more on the traditional notion of states as the main duty bearers of human rights obligations. Here, state parties must ensure that their domestic law provides for a comprehensive and adequate system of legal liability for human rights violations or abuses in the context of business activities, including those of a transnational character. And the treaty also, since 2014, the treaty has reflected some largely settled or very familiar concepts in business and human rights, stemming from the UN Guiding Principles on Business and Human Rights. And we can see that in Article 6 of the treaty, which relies heavily on human rights due diligence principles. So if we turn next then to the environmental provisions on the next slide, Annalisa. Thank you. Thanks. So each version of the legally binding instrument has included some kind of reference to environmental rights in some form or another. I think what's really interesting is that this third revised treaty seemed to have, in some ways, quite heavily relied on environmental rights, or at least have recognized the importance and kind of intersectionality between human and environmental rights. So Article 2.1, which is, talks about the definition of human rights abuses, says that abuses shall mean any direct or indirect harm in the context of business activities, and draws explicit links between human rights and environmental rights. And also this version includes the recognition to a safe, clean and healthy environment and sustainable environment. As some of you may know, this was a right that was recognised for the first time, well, again, not legally binding. It was recognised last year and provides this corroboration to a healthy environment, that that we require protection to a healthy environment. So that is one of the areas in which environmental rights have been incorporated into this treaty that is originally really very much meant to be about business and human rights. Article 4.2 Article 4 is on the rights of victims, and Article 4.2 describes that victims must be guaranteed environmental remediation and ecological restoration for abuse caused by corporate actors. Article 5 also looks at the protection of victims and again recognises the need to protect human and environmental rights defenders, requiring states to take adequate and effective measures to guarantee a safe environment to promote and defend human and environmental rights and ensure that these defenders are free from threats and violence as well. And then Article 6 again talks about human rights due diligence measures and expands on the previous two versions of the treaty when it talks about the need for companies to undertake environmental impact assessments and report publicly on environmental and climate change standards. So the next couple of slides deal with whether or not this current form of the treaty can actually provide for or enable corporate accountability for climate-related human rights abuses. And I think it's really important to talk about the actual, maybe the symbolic importance of a treaty that has actually reached this stage. I previously heard it described by Nadia Bernaz that this is a once in a generation opportunity to try and get some kind of corporate accountability in international law, directly or indirectly. And as Annalisa and Jacques Hartmann talk about, we are witnessing legal history making, which continues to interweave human and environmental rights together. It's important to recognise that intersection and also demonstrates and acknowledges that established practice of using human rights law and institutions to protect environmental interests as well. So I think we need to take kind of a moment to recognise that is a very significant symbolic achievement, and really reinforces the idea that these kind of this corporate accountability for climate related abuses is not going to go away anytime soon. But if we just turn to the next slide, then those are our reasons to be cheerful. But I think there are many areas of concern in the treaty, both in terms of the scope of the treaty and its concepts, but also the political will and motivation. And I'll just kind of tease some of those ideas out now. So the first issue that I think is really important and one that is quite a concern is the jurisdictional scope of the treaty itself. So Article 9 of the third revised draft requires states to avoid impeding judicial processes with obstacles such as forum non-convenience, and instead adopt a form of necessity approach. And this requires courts and state parties to exercise adjudicative jurisdiction over non-domiciled entities if no other effective forum guaranteeing fair trial is available. And then victims can bring complaints on a range of bases as well, which are quite expansive. And there have been already numerous objections to the jurisdictional scope of each version of the treaty. And for the third revised treaty, we've heard complaints from the UK, China, and Brazil, who kind of talk about this theme of this is a real overreach of state sovereignty. And I think this lack of agreement on the jurisdictional scope will hinder any ability for this treaty to really translate into corporate accountability for climate-related human rights abuses. There's also concerns over conceptual mishmash, as I call it. So environmental due diligence is not explicitly defined, but the current draft does bring in notions of due diligence under human rights and environmental law, kind of closer together conceptually. But again, we've had complaints or concerns raised by the EU, Brazil, and the Philippines, who've all kind of expressed skepticism over the inclusion of environmental rights, with the concern that this really just increases conceptual confusion for the treaty and in practice, might not have actually any benefits for victims trying to access remedy, or even for companies trying to work out what this environmental due diligence means. So the EU, for example, queried the scope of such environmental rights, suggesting that this term has no clear meaning in international law. And yes, so the draft doesn't really mention any detailed definition of environmental due diligence, only that environmental and climate related impact assessments must be carried out. And this is quite problematic because it leaves a wide margin for what the material scope and requirements of environmental due diligence might be under the treaty. I think we can also say that while we do recognise in Article 1.2 that there is the right to the clean, safe and sustainable environment, the treaty doesn't recognise other rights which have been championed by states such as Ecuador in terms of the rights of nature, for example. And this is regrettable because these are very innovative and progressive approaches, but they're really not recognised at a global level yet. So perhaps if they were included in this, it could provide a path for recognition. But again, the flip side of that is that might also hinder negotiations of the treaty process as well, in the treaty process. And I think really at the minute we're seeing quite a risk-averse approach by states. And so, if the legally binding instrument aims at alignment with already internationally accepted human rights, references to kind of any progressive rights like the rights of nature might be seen as premature or as a hindrance right now. In terms of looking kind of at the wider political landscape, I would say of the treaty negotiations, is that many states and stakeholders have really expressed disagreement with very basic aspects of the text. Again, I've mentioned a few examples there. Definitions, jurisdiction, scope, are all things that have been hotly debated. And I think while there is a real enthusiasm for the treaty, and it should be seen as a very positive step forward, I think the outcomes of the negotiations at this point are so uncertain and face major opposition, particularly from industrialized states where the majority of transnational companies are domiciled. And I think really what we need to think about is whether or not this divide in the international community and the disengagement of many states could undermine the quality of the actual approved text and subsequent ratification and implementation of the treaty. I think, rather than the issues that I previously discussed in terms of advancing environmental rights under the treaty might only lead to more tension and more potential jurisdictional conflict, without actually lowering barriers for victims, which is the main thrust of what should be the main thrust of this treaty, and resolving any actual problems in terms of climate-related corporate human rights abuses. I also, Claire, who's not with us today, has also discussed the limits of the forum, whether or not a treaty and the drafts of this treaty at the moment really will ever succeed in the forum. So Claire talks about the fact that it's too expansive already, and on a practical level might not actually work or only work for very narrow categories of harm. And instead, Claire looks at what's necessary is to harness the resources that are already invested by governments and businesses and civil society, and act upon kind of ready-made instruments that have been ongoing since the guiding principles, such as national action plans for business and human rights. In terms of other, on the other side of that scale, some also talk about the fact that the treaty actually doesn't go far enough, and that there needs to be direct human and environmental obligations on corporations. And this is what Nadia Bernas talks about, looking at other treaties for inspiration, particularly the United Nations Convention on the Law of the Sea, which includes obligations both on states and corporations. And I think that really gives you maybe a picture of just how not to be too pessimistic, but to be realistic, that these are very real concerns. And if there are to be a progressive realization of environmental, climate-related corporate accountability, for human rights abuses, I think we really need to be very aware that this is a process which has already been slow since 2014, and will continue to only inch towards things and might not be useful for victims who are going through these environmental damages right now.
At the Hamad bin Khalifa University, Qatar, as well as the Chancellor's Fellow and Director of the Institute of Oil, Gas, Energy, Environment, Sustainable Development of the Baba University, and he in Ado Ekiti, Nigeria. He's also been appointed as Senior Fellow, Senior Research Fellow at the Institute for Energy Studies at the University of Oxford, and also visiting professor at Columbia University, Cambridge University, Oxford University, and the China University of Political Sciences and Law. Professor Alaoui's son is among the world's most celebrated scholars, practitioners, and advocates, and a leading expert in the fields of natural resources law, environmental law, sustainable development law, and human rights law. And many of us will be familiar with his meticulous and sophisticated academic writings evaluating the intersections between these different fields. In 2020, he was appointed as the independent expert on the African Union's Working Group on Extractive Industries, Environment, and Human Rights Violations in Africa. Professor Alaoui's son serves as on the executive committees and boards of several organizations. He is a vice chair of the International Law Association globally. Professor Alaoui's son is a regular media commentator on all aspects of natural resources, energy, and environmental law. Professor Alaoui's son is a prolific and highly regarded scholar and has published over 100 influential peer-reviewed articles, books, and reports on energy finance, sustainable development law, and extractive resource governance. His most recent publications include the single-authored book Environmental Law in Arab States, published by Oxford University Press this year. He's the general editor of Local Content and Sustainable Development in Global Energy Markets, published by Cambridge University Press last year, 2021. He's the author of Extractive Industry Law in Africa, published by Springer in 2018. And he's also the author of the Human Rights-Based Approach to Carbon Finance, published by Cambridge University Press in 2016, and the general editor of the Climate Change Law and Policy in the Middle East and North African region, published by Routledge in 2021. So pretty much this publication is touching upon all the core themes of our conference. Professor Alaoui's son is mentioned, as I mentioned in my introduction to this conference yesterday, and I was referring to you and also to our other keynote speakers, that the strength of your scholarly contributions and advocacy and practice in advancing the integration of human rights standards in natural resources governance is unparalleled. And it is really a real honor to have you here today to share your expertise with us. Thank you very much for accepting our invitation to deliver the closing keynote speech to our conference. Professor Alaoui's son, the floor is yours. I think you may be joining us from London because you're due to attend the 5th Arab Lawyers Forum in London, but I'm not entirely sure. But I hand over the floor to you to discuss the topic of a highly topical subject, business, human rights, and the search for green growth, corporate responsibility, and strategies for advancing a net zero future. Thank you.
Thank you very much, Dr. Pereira, for the very wonderful and kind introduction. And you're almost correct. I'm joining from Cambridge. I did attend the conference in London, and I attended another session in Cambridge, UK last night, and I'm still here. So it's a great pleasure. I've had the privilege of listening to the different presentations, especially those made today, and I must really congratulate you, Dr. Pereira, for bringing together a very wonderful roster of high caliber speakers who have done justice to the themes. And I think what you've done is a significant contribution, because we are, the topic is timely, it is important. Now the whole world is looking for the way forward. So the more we discuss these issues, the better for all of us. So thank you. It's my pleasure to speak on the subject of business, human rights, and the search for green growth. When we were thinking of this topic, what came to mind was a recent discussion that I had with a CEO of one of the big Fortune 500 companies. And, they had asked me, what exactly do you guys want? That was the question. Everyone is talking about climate change. Everyone is talking about human rights. Everyone is talking about net zero. What do you want from us? Do you want us to shut down? Do you want people to lose their jobs? What exactly should we do? And I thought that was a simple question that, what you should do is quite clear. Clean up your production processes, ensure that your operations respect human rights. But, as the discussions went on, it became clear to me that those of us as academics working in this area can do more to clarify what responsible corporations should do in terms of achieving green growth and in terms of advancing net zero future. So I'm going to speak about that in a while. I'll talk about what responsible corporations should be doing at this stage as we move forward. And I see my talk as tying together all of the key points that have been made in this wonderful conference over the last 2 days. So I will simply talk about the linkages between business, human rights, and green growth, why these three key concepts are so intertwined, and how we can reflect that in analyzing the emerging risks for corporations and business enterprises in light of these three key topics. Then I would give some practical suggestions on that question of what should responsible corporations be doing right now when it comes to risk mitigation, when it comes to risk management, as well as when it comes to contributing their own quota to a net zero future. So, of course, in thinking about this topic, I'll just give a little bit of background, and I could see that a lot of people have talked about this issue of increasing protests and conflict and issues associated with the implications of natural resources operations in different countries across the world. And studies show that majority of the conflict associated with natural resources production across the world are increasing. Whether you're talking about a 46% prevalence in Latin America and of course Africa, Asia, you see that. Well, okay, I'm still safe. Yeah. Well, so what I find is that many of these conflicts are associated with a clash of interest. On one side, think they are doing enough. And on the other side, the public, academia, civil society think they are not doing anything at all, or they are not doing enough. And you will all agree with me that that is where we find ourselves right now. And you can see, we can illustrate it with this diagram from the mining sector, whereby mining companies that I've spoken to and in my different, engagement, they tell you, I think the hotel here is maybe doing a test fire alarm, but it keeps coming on and off, but I hope it will stop. Well, the mining companies will tell you that they're doing enough, but it seems the public, the local communities do not appreciate their contributions. While the communities are saying, well, you're not doing anything, you're only damaging the environment, you're only making life difficult, you're not engaging enough, you're not. So you see that clash of interest, divergence of opinion, which often leads to conflicts, protests, and even litigation. And the last panel talked about climate litigation and the likes. So you see that many of the questions that we're asking today, the foundation is a complex interplay of structural, contextual, and governance questions. And if you want to map those questions, you see that there is the contextual sources of this conflict, whether you're talking about the different objectives of businesses and local communities. While businesses are more interested in profit, local communities are more interested in sustainability. and ensuring that operations do not damage their environment. There are issues of lopsided contractual terms. We've seen contracts that do not generally reflect the feelings and aspirations of the local communities. There is issues of distrust and breakdown of relationships. But the one I would love to focus more on will be the governance factors. Of course, the structural factors are there, especially in many countries like Nigeria, where you see concerns about pollution control technologies not being available, lack of equipment by government, and poor infrastructure and the likes. But if you look at the governance factors that are the drivers of this business and human rights questions, they relate to issues of lack of transparency and accountability, issues of inadequate training, poor sensitization. And these are all issues we've been talking about over the last 2 days: social exclusions, injustice, violation of human rights by local communities, issues of illicit financial flows as well, endemic corruption. Much of the funds that should be used to develop countries have been taken out by corporations, multinational corporations, taking out funds illicitly, whether through tax evasion, and all sort of sharp practices that are designed, to sort of ensure that profit is maximized, most times to the detriment of the local communities. And as well, the issue of weak enforcement and monitoring of climate and environment obligations as well is increasing, especially these days with concerns about climate change. And all these things that I've mentioned, they are the key concerns when it comes to business and human rights literature. These are the key business and human rights questions that we are faced with today. Now, let me talk a little bit about the climate change question. You'll see that the climate change question has become more pressing. It is very clear now to everyone that climate change is a human rights issue. Whether you are talking about the direct impact of climate change caused by corporations, through failure to mitigate greenhouse gases that cause climate change, for example, using of technologies, plastic packaging and the likes. These are direct ways in which corporations can contribute of climate change. The indirect ways are some of the things that were talked about by the speaker, talking about environmental justice and the likes. How even efforts to address climate change may even be causing human rights problems on the ground. And you've seen issues relating to CDM projects, REDD+ projects, which originally in their design are meant to advance environmental objectives. But you see that improper implementation, ineffective planning, leading to social exclusion of women and youth from decision-making, land grabs. You've seen greenwashing and deceptive marketing in which corporations are saying, oh yes, we're doing a lot to combat climate change. I've been involved in a litigation on greenwashing, one in the UK, one in Nigeria, in which a company was sued for claiming that this is their sustainability program, but in the end, it was all a lie. So you see that, when you drill down into greenwashing, you see that it's a violation of the fundamental right to information. Access to information is a human right in international law and in many countries. So when you give me misleading information, it's a violation of my right to information, and the like. So climate change raises direct and indirect human rights questions. And some of these obligations of corporations to address these problems that I've mentioned, whether you're talking about climate change, illicit financial flows, these obligations are in a wide range of instruments. And of course, over the last 2 days, some of these questions have been mentioned. Some of these instruments have been extensively discussed. Whether you're talking about the UN guiding principles, we talked about, of course, if you look at Pillar 2, it's very clear. Business enterprises must do all that they can to prevent, investigate, punish, and redress human rights abuses in all of their operations. That's very clear from the guiding principles. We are all hoping that a legally binding treaty will even, be in place soon to move it from just, aspirational document to much more binding obligations. Of course, if at the African Union level, you have a wide range of instruments. Talking about, if you look at the African Union's action plan, for example, another non-binding instrument, but very, very strong in terms of saying in mining, any mining activity across the continent must respect human rights, environment, social, human rights, health considerations must be put in place. If you look at the resolution by the NAMI, if you look at the NAMI resolution on the NAMI declaration on the African Charter, it talks a lot about the need for public participation, accountability, access to information, non-discrimination, and the likes in all natural resource extraction activities. If you look at the report of the African Union Panel of the Wise as well, very, very strong document. The Panel of the Wise was constituted by the African Union to investigate the sources of conflict in natural resources development and to come up with recommendations. And they said, well, there is a need for active consultation and involvement of all stakeholders, including local communities. So businesses must ensure an active consultation and involvement of all stakeholders, including local communities, women, youth. There's a need for government and businesses to ensure transparency and accountability prior to and during natural resource development. If you look at the ECOWAS conflict prevention framework as well, ECOWAS is the economic community of West African states in West Africa. Again, it talks about the need for natural resources management. They need to ensure that the development of natural resources are transparent, equitable, environmentally friendly. And even beyond Africa, you see, you know, a repetition or a development of similar standards. Whether if you look at in North America, you see the Inter-American Court of Human Rights giving an opinion at the request of Colombia, saying that climate change is actually a human rights issue. Climate change violates human rights. At the EU, you see, of course, the EU strategic framework, which talks about the need to incorporate human rights into all impact assessment on an ongoing basis, same as the OECD guidelines. There are a wide range of soft law instruments as well, whether you are talking about the PRI, principle of responsible investment, a very important initiative spearheaded by the UN, which talks about the need to integrate social, environment, and sustainability standards into all investment decision-making. If you look at the Equator Principles, again, a voluntary initiative, which again talks about the need to consider environment, social governance issues in project planning, in even by financial institutions in giving loans and giving funding for projects. Of course, even at the domestic level, you see a number of countries now having national action plans. And you can talk a lot about them. For example, you see this law number 1523 in Colombia on disaster management and the Plan National on human rights and environment, again in Colombia. And you can talk about the French vigilance law as well. All of these instruments that I've mentioned have been covered over the last 2 days. So it is crystal clear that there is a coagulation of opinion and there's a coagulation of principles which highlight the need for companies, investors, lenders, insurance underwriters, all of us in the corporate world to implement robust environment, social, and governance safeguards in order to achieve green growth. The concept of green growth is not new. It's simply the idea that we must achieve development in a way that will deliver economic benefit without sacrificing environmental and social standards. So a development approach that seeks to deliver economic growth that is both environmentally sustainable as well as socially inclusive. So green growth incorporates all aspects of environment, social, the three pillars of sustainable development. So the pillars of green growth are four. Number one, efficient and sustainable use of resources, especially water, energy, and food resources, which are increasingly scarce these days. They need to ensure that they are properly, there's conservation and they are not wasted. And it's not only water, energy, and food resources, whether we're talking about natural resources as well, such as oil and gas, minerals, and the likes, there is a need. The green growth norm talks about the need for efficient and sustainable resource use. The second aspect is the need for green economic opportunities. And of course, ever since the UN elaborated on green economy, it's become clear that countries must use, we should not think of sustainable development as something that can hinder economic growth. Rather, we should think of sustainable development as a tool for creating jobs, green jobs. And when I speak to CEOs in oil and gas industry, I say, no one is telling you to shut down. We're simply saying, how many of your existing portfolios can you describe as a green portfolio, as a green job? And I've seen it in practice. A number of companies are now, creating roles such as greenhouse gas emission verification manager, or greenhouse gas or waste audit manager. Those are green jobs. Any job that will lead to sustainability, increase in environmental protection, those are green jobs. The more you integrate green jobs into your programs and plans, the more you are advancing green growth. We're talking of natural capital protection as well. Natural capital will include natural resources, air, land, water. How can we ensure their conservation? How can we ensure that they are not destroyed, especially issues relating to the theft of natural resources, the destruction of cultural heritage? How can we address them? How can corporations contribute to that, to addressing, through programs or through funding? How can they contribute to natural capital protection? We're talking about social inclusion, the need for human rights due diligence, the need to ensure that women, youth, and normally typically marginalized groups are carried along in development through gender proofing or through all sort of vulnerability assessment that we ensure. So these 4 pillars are the pillars of green growth. So what we are seeing now is the need for companies, business enterprises, to reflect on how they are integrating these standards in their operations. And I love to say that green growth is not new. It's simply a very elaborate implementation of the prevention principle of international law. It is easier, better, more cost-effective to think about these issues before they become problems. So corporations have a duty to ensure that their operations are anticipating social issues, anticipating human rights issues, anticipating environmental issues, and mitigating those risks across their entire value chain. So the test for green growth is, to what extent are you anticipating and addressing these key risks across the entire value chain? And of course, when you see, if you see this this article, this chapter that I wrote on corporate accountability for the natural environment and climate change, it sort of maps out these human rights obligations very clearly in terms of the panel principles. P standing for participation, accountability, non-discrimination, empowerment, legality. Panel. What should responsible corporations do to advance green growth? In terms of participation, they must consider to what extent are we identifying all potential sources of social, environment, and human rights risk. We must ensure that we then communicate those risks and provide an opportunity for all that will be impacted to take part in decision-making and to influence decision-making. Participation goes beyond, I like to say that participation goes beyond public participation. In one of my work, I did analyze that we focus a lot on public participation in terms of deliberative democracy, or being able to take part in decision-making. But I argue that public participation goes beyond deliberative democracy. It also includes participation in employment opportunities, local content. You cannot say that I have participated if all the jobs go to men. The oil and gas industry worldwide remains a men's club. That is not participation. So we must not think of participation as just deliberative democracy. Oh, they were involved in town hall meetings. What about participation in economic activities? creating opportunities for typically marginalized groups, whether youth, women, or visible minorities, through local content initiatives that would empower them. Accountability. Responsible corporations must monitor and redress human rights and environmental violations across their entire procurement value chains. It's one thing to say, well, we're doing all that we can, as a company, but then you are getting goods, you're sourcing goods from a country that that the money you're paying is only going to, empower warlords to fight unnecessary war. And I talked about this issue of conflict diamonds, and I likened it to what is going on in Russia right now. And I say, anyone buying gas from Russia at this point is only empowering to commit war crimes, and it's probably not ethically, mindful of how that activity might disrupt the robust implementation of international human rights law. We talk about compliance with net zero standards and mitigation and adaptation measures. To what extent are we as a corporation compliant, in our operations with net zero emission standards? Are we mitigating greenhouse gases? Are we ensuring that at least we are reducing our levels of emissions in line with domestic and international law? You talk about non-discrimination, and I've mentioned this, ensuring that vulnerable groups, particularly women and youth, have equal rights to participate effectively in project management and implementation. Empowerment and access to information. These days, access to information will include disclosure, complying with disclosure requirements, sustainability and disclosure requirements. Are you, as a company or a corporation, communicating what you're doing? Like we like to say in law, justice must not only be done, it must be seen to be done, right? So if you say you are contributing, we're doing all that we're doing, don't forget I started my lecture by talking about that. It seems there is always a clash. You think you're doing enough, but the community say you're not doing anything. That's because you're not communicating what you're doing. And at times they say, but we release this report, but you release the report in English, and you know that it's a report that will be read in the Niger Delta community where they don't speak English, then you're not communicating. So not only should you release sustainability and climate disclosure reports, you must ensure that such reports are, they are written in a language that is understood. I was in Colombia the other time, and it was the problem as well. Sustainability reports in Colombia in English. Meanwhile, you know that a wide majority of the people of Colombia do not speak English and do not read in English. So why did you not produce the report in Spanish or in other local languages that they would be able to read? Is it timely? You have on the website your report of 2017 in 2022. Is it recent? Is it accurate? Is it relevant? And then you talk about legality and access to justice as well. The need for respect for human rights across the entire value chain. And the British, the decision of in the case of Videnta and Longwe has made it very, very clear by the British court that it's not enough for you to say, well, it's not us as a parent company, it's our subsidiary that is violating human rights. Well, that decision makes it very clear now that, well, even you might be responsible for the activities of your subsidiary. So long as there is that, it is clear that you maintain control over their activities. So that is why the entire value chain question is now interesting, because it's no longer just what you're doing as the parent, but you must ensure that even your subsidiaries and everyone associated with you are actually advancing green growth. What about the need for cooperation? We think of cooperation mostly as cooperation in international law, but I like to also think of cooperation for businesses in terms of cooperating to ensure that justice is done. Most times you see that the causes of pollution on the ground is that corporations, business enterprises simply abandon their pollution and run away, especially in countries where institutional quality is weak or low, or law is weak. There's no financial assurance mechanism. So there's no sustainable decommissioning. They just finish, they leave. There is a need for cooperation in terms of cooperation in cleanup, in remediation, in compensation efforts, in line with the polluter pays principle. And of course, there's a clear need in this work. I discussed the need for businesses to establish their own public complaints unit as well, so that they can get feedback about their work, about their impact on local communities, and address those impacts. It's not enough to say, well, access to remedies, access to justice, the role of the state. What about the role of the corporations themselves and the business enterprises to get feedback, to deal with those feedback in a timely manner? So these are the wide range of issues that business enterprises must be aware of these days, and must take active steps to ensure that they are integrating these business and human rights obligations in terms of the panel principles across the entire value chain of their operations. And I'm just going to wrap up by suggesting a wide range of techniques. We've talked about the corporate obligation. Now I can talk about corporate strategies to achieve some of these things. And I've identified 5 steps to effective risk management. Number 1 is risk identification. I think every responsible corporation should do a thorough evaluation of their greenhouse gas footprints and ask the question, to what extent will our operations contribute to greenhouse gas emissions, and how can we reduce that? Also evaluate actual human rights risk through a comprehensive human rights due diligence approach to understand how your operations may be hindering green growth. And of course, that will lead a corporation or a business enterprise to be able to set a realistic risk appetite and to consider liability scenarios. Number 2 is risk control. And I talk about the need for an enterprise-wide risk management approach. What this simply means is there is a need for every business enterprise to undertake what I call process change and product change. Process change in terms of what are our processes or policies that are contributing to human rights, and how can we change those processes, whether it is the process of our procurement, the way we recruit in a company that does not have a clear policy to recruit men and women groups on a 50-50 basis, then there's a need to change that process. There is a need to ensure firm-wide processes and policies that will advance business and human rights and green growth. There's a need for product change as well. Is there any of our product that is not sustainable or is not climate smart? And this we talk, when you're talking about those in the fast-moving consumer goods industry, such as those that manufacture beverages and the likes, and coffee and tea and makeups and cosmetics, you ask them, why are you using plastic packaging? There is a need for product change. There is a need to change some of your products to ensure that they are climate smart. Your packaging, everything you're doing, climate smart, green labeling, and the likes. And of course, that process of identifying process change and product change will lead you to mobilize resources, ensure training programs for your officers on the ground so that they will be able to implement those things. And there is a need, of course, when you talk about focal point, there's a need to then begin to ensure that you integrate ESG competent officers across the entire management and board. And these days, when I see companies that do not have anyone on the board that is competent in environmental law or environmental management, I tell them, you are playing with significant risk, because these days, the environment, human rights, business and human rights norms, green growth, these are key issues of the day that can easily expose you to risk and litigation. So why don't you appoint people with that expertise, whether on your board, whether on your management team, so that they will be able to identify risk, manage those risks, and ensure that even community relations are done the right way. Of course, I've talked about corporate reporting, the need for proactive, timely, and accurate disclosures, whether you're talking about your sustainability strategy, the climate disclosure, the level of greenhouse gas emissions that you have, that you had last year, what you have this year, what you're doing to reduce your carbon footprint and the likes. Even reporting on human rights cases that you've encountered on the ground and what you did to respond. These show that not only are you thinking about business and human rights norms, you are actually implementing them. By the time we start seeing human rights reporting in corporate reports, then we know that a corporation is actually taking human rights seriously in their activities. Of course, there is a need to track cases, to educate your field staff, to ensure follow-ups, to ensure that not only do you have this new policy, it is actually being implemented on the ground. Well, in conclusion, it is very, very clear that the expectations of business enterprises to anticipate and address climate-related risk is no longer an option, but a necessity. And I've talked about the need for process change and product change to ensure that not only are your activities not contributing to human rights violations, you are actually advancing and moving forward the norms of green growth. There is a need to ensure that human rights issues, when they occur, they are promptly reported and they are dealt with. And I've talked about the fact that corporations can no longer rely on corporate veil or and expect immunity because of the different structures that they have in different countries. Or it's not my subsidiary here, or it's not. There is now a need to ensure that human rights risk analysis is comprehensively done with respect to subsidiaries, with respect to even those that supply in terms of your procurement value chains. So it's very, very important for a corporation to do this comprehensive integration of business, human rights, and green growth norms across the entire. And by so doing, I think business enterprises will be contributing significantly to a net zero future that we all desire to see. And I look forward to working with all of you to advance some of these principles as we go forward. Thank you very much.
Thanks so much, Professor Damilola Louison. This was a fascinating closing keynote speech.